Welcome back again. Now we are going to discuss the next trial from the CRPC, and this is very interesting. This is called as the Warrant trial. Now we are discuss this summon, that is the session trial. So far as the Warrant trial is concerned, there are two types of the Warrant trials. Before we start the lecture, what is Warrant trial? What is summons trial? Or what is we call as summons case or warrant case? We have already discussed while defining the some of the provisions under the CRPC. Of course, we'll discuss here also. Warrant trial. There are two types of warrant trial. One is called as the on police report, and other one is otherwise than the police report. Section 238 to section 250, rather 248 itself, but 250, since the entire chapter deal with this, are governed by these two types of the trials, that is called as warrant trials. And under the chapter of the warrant trial, again the provisions of section 238 to section 248 again divided into two groups. One is what do you call as the warrant trial on police report, and other one is warrant trial otherwise than the police report. Section 238 to section 243, this particular section deals with warrant trials on police report, while section 244 to section again 247 or 248 deals with the provisions for the warrant trial other than the police report. Now, before we'll discuss how this came into picture and why there is a two class of the warrant trial, we must understand what is this warrant trial or warrant case first. Especially, section 2 W defines summons case. Simply it says the case related to the offense not being a warrant offense. That is called as warrant case. It means summons cases are those cases which are not the warrant cases. This is what the meaning of the section. Whereas the warrant case, it means that it is a case for which the offense which is punishable, death, imprisonment of life, or the imprisonment for the term extending 2 years. So what the that is what the definition under section 2x says. What is this definition trying to say? This simply means the offenses for which the punishment is more than 2 years, that particular offenses comes under the warrant cases. Whereas the offenses for which the punishment is less than 2 years, that offenses we call as the summons cases. Now, based on this initial discussion, let us start the discussion of the warrant trials. Now, when these two categories came into picture, if you remember in class, we had discussed one example. A lady, that is we call it A, she went to the police station, and after going to the police station, she deposed before the police officer that her husband, her mother-in-law, father-in-law, and other persons, whatever it may be, they treat her in a cruel manner. Husband beat her, due to which the injury is caused. I'm adding this because of the provisions has to be added. Or rather, there was a head injury to her vital part of the body by the deadliest weapon, and she has narrated all these incidents to a police officer. Now, the moment she has deposed to the police officer, you all are aware, section 498 is attracted. If you go through the section, the schedule 1, section 498 A deals with the cognizable offenses. Now, what is cognizable offences? So the CRPC itself defines, that is, the offences for which the police has taken the cognizance, or the offences which are shown as a cognizable in a Schedule 1. That those offences are cognizable. Now, what is the connection of the cognizable offence with the police officer? Now, whenever there is a cognizable offences, it is the mandatory duty of the police officer to take a cognizance of this. Now, what is this concept meaning of the taking the cognizance of police officer? Let us take with this example. Now, if the police, that lady went to the police station, and after narrating her entire story, if the police officer he realized something is there, something that is to which he can take the cognizance as per the Schedule 1. And fortunately for lady, if suppose that particular constable recorded her information as per section 154, we call as FIR. I'm saying fortunately. This is the stage where warrant trial is divided into two parts. So everything is based upon the constable. If he say yes, ma'am, whatever you are saying is a cognizable offense, I must take the cognizance of this by registering the FIR, and by following the due process under section 154, he has taken the notes. It has to be read over to the informant. Copy is hand over, and the next stage came into picture. That is we call as the investigation. Then he arrested the accused person. 167 came into picture, produced before the magistrate. Since it is trial by the magistrate, which is not serious as to the session trial, the magistrate granted the bail, or might be they might have taken the anticipatory bail as per under section 438 of the CRPC. That will later on discuss. That is we call as a pre-arrest bail. And now the investigation is completed and charge sheet is filed. We'll take a pause here. This is one thing. This is warrant trial, because the definition which we will discuss, what is warrant trial, for which the punishment is more than 2 years. If you go to the Schedule 1, section 498 says 3 years, or if it is a suppose the lady deposed a constable that the injury is caused to her forehead, and section 323 is attracted, then again the more than 3 years. Therefore, it's a warrant trial. So again I will come back. When the classification or the two part of the warrant trial on police report or otherwise police report came to be divided. Now the same lady went to the police station, she narrated entire story, but the constable says, ma'am, nothing new. I don't found anything cognizable. Rather, I will whatever you are taken in writing, I will acknowledge you. And he refused to take the cognizance, irrespective of the fact that the offences are cognizable. Now, this same lady, but the chapter is divided into two parts. One part when the police officer has taken the cognizance, other part when police officer has refused to take the cognizance. Let us take the example what is to be done after the police officer refused to take the cognizance of the cognizable offence. The lady, after refusing the taking the cognizance by the constable, she went to the lawyer, and while going to the lawyer, she narrated entire story to the lawyer. She says, "Sir, this has happened." A lawyer, again subject to the condition, if he is aware with the position, he said, "Don't worry, ma'am. We'll do one thing. We'll file the private complaint." And accordingly, the lawyer drafted the private complaint. They presented the private complaint, that is we call as section 190, and that is we call taking a cognizance by magistrate. After presenting the complaint to the magistrate, if the lawyer he prayed to the court, "Sir, this being a cognizable offence, the police would have taken cognizance, but they refuse. This is an injustice caused to the lady," and he prayed investigation for the matter. and if the magistrate realize something cognizable, magistrate may direct the investigation by using the power under 156 sub clause 3, or the magistrate may send the matter for what do you call the inquiry under section 202. But if the magistrate realize this is not the fit case to send the matter for the investigation nor for the inquiry, and he choose the third aspect, that is we call as issuance of process. Now here there are two parts. Same complaint, same informant. If the police officer take the cognizance, it is also called as a warrant trial. And after taking the cognizance, he filed a charge sheet. It comes under a title we call as warrant trial on police report, because charge sheet in legal sense we call as police report under section 170 sub clause 2, and therefore it's a warrant trial on police report. Why warrant trial? Punishment is more than 2 years. Why police report? Because charge sheet is there. But when the police officer refuses and when the private complaint is filed, it is called as warrant trial otherwise than the police report. With this, I hope you understand this initial discussion. With this, let us discuss what are the provisions made, because section 238 to section 250 deals with these two trials. But we'll discuss first warrant trial on police report. What is police report? That is defined under section 173 sub clause 2 sub clause 1. That is we call it charge sheet. Now let us see the provision warrant trial on police report. The first and foremost things came into picture under the warrant trial on police report, the definition of the police report. Section 2R of the CRPC defines police report. It means a report forwarded by the police officer in respect of the offences to the magistrate under section 173 sub clause 2 of the CRPC is called as the police report. That is we call as the we call in other way, that is charge sheet. Now if you go through the stages, there are only 6 stages compared to the session trial. This is very less trial and very simple also. Now what is the first stage? Police officer registered FIR, investigation completed, police report is submitted. Now we are going to discuss after the submission of the report to the magistrate. I will take a pause here. When there is a warrant trial on police report under section 238 to section 250, please bear in the mind there is no question of committal, because these offences are triable by the magistrate itself, and therefore there is no question to transfer or to commit the matter by using the power under section 209 to the session court. So there is no provision for committal, and therefore directly, instead of committal, directly the process, that is the provision under section 238 came into picture. That is first stage under section 238, that is compliance of section 207. This is a mandatory duty on the magistrate. This is the first stage under the warrant trial on the police report. What is the duty of the magistrate? Compliance of section 207. It is the prima facie duty of the magistrate to see whether there is a compliance of magistrate section 207 or not. See, this particular provision we have already discussed while discussing the warrant trial also. What is this compliance? Compliance is nothing but all the papers along with the charge sheet has to be submitted to the accused person, and therefore magistrate shall satisfied himself the police officer has supplied all the copies to the accused person or not, because again the principle of natural justice, principle of the under the constitution, no one shall be unheard, and therefore unless the copy is supplied to the accused person under section 207, magistrate cannot open the trial, whether it is a session trial or warrant trial on police report. So after this compliance, then next stage, and this is very interesting stage came into picture, that is under section 239 of the CRPC, discharge of accused person. Now if you remember, under the session trial we had discussed appointment of public prosecutor, the opening trial by the public prosecutor, such kind of provision is not there, but it's an internal part. Now what is the provision under section Once once the charge sheet is filed by the uh, police officer to the magistrate, then after receiving the entire police report and after reading the entire charge sheet, now in this particular provision under section 239, the magistrate has to go through the entire charge sheet, whereas in the session trial, the public prosecutor has to depose before the magistrate. Of course, the magistrate will hear after reading the trial. I'm sorry, the charge sheet. Magistrate will hear the public prosecutor. What are the evidence they have collected during the investigation? And if after reading the charge sheet, after hearing the public prosecutor, if the magistrate realizes there is nothing in the matter, then he can discharge the accused person. See, in session trial, it was a third stage, while in the warrant trial on the police report is the second stage, exactly after reading the charge sheet. So, if there is no prima facie case made out, then the magistrate can directly discharge the accused person. That is the initial discharge. Again, and this stage, the accused played no role. No question was put to the accused person, nor to his lawyer. This is just simply by going through the charge sheet prima facie. That this is just in order to avoid the valuable times of the court. However, if after going to the charge sheet, if the court realizes there is a prima facie case made out, or there is a sufficient case, I'm not saying sufficient case for the conviction, sufficient case for the conducting the trial. See, the sufficient case for conviction is different than the sufficient case of conducting trial. Sufficient case to convict, that is the observation of the magistrate after collection of the entire evidence, that is after conclusion of trial, while sufficient case to conduct the trial, that is the initial stage. And therefore, after going through the charge sheet and after hearing the prosecution, if the court come to the conclusion this is not a fit case to discharge the accused person under section 239, then he may proceed for the next aspect, that is we call as framing of the charge. Now again here, that this is under section 240 of the CRPC. Here again magistrate, by using all the requirement which we have discussed in the session trial, he may read over the charges, that is we call as allegations against the accused person. The magistrate has to explain the accused person what are the charges, what are the consequences of the charges, what is the punishment of the particular offences in a vulnerable language, or the language which he understood by the accused person, or sometimes if the accused person is not in position to understand the language, he has to explain what is the meaning of particular charges. Say for instance, sometimes simply by saying, the magistrate may say you are charged under section 420. Generally, the even ordinary person can understand what is 420. It's a cheating, the punishment for the cheating. But if someone say criminal misappropriation of property, the it is duty of the magistrate in that case to explain what is in what way the misappropriation has been done by the accused person. This is the mandatory duty, and this particular stage came into picture when magistrate realized he is a competent to convict the accused person, or to conduct the trial. And after reading and explaining the trial, he has to ask the accused person whether he plead guilty to the offense which he had tried or not. This is again the stage similar to the session trial which we have already discussed. There are several judgments on this point which we have found in your written notes, which are going. I'm going to again submit you on your group. And once the court asks, that is, the magistrate asks the accused person, "Are you plead guilty?" If he says yes, I plead guilty, I accept my guilt, then section 241 came into picture. We call as conviction on plea of guilt. This is when the accused person accepts the guilt under section 240. Here the word, please bear in the mind the difference between the session trial and the magistrate, that is the warrant trial and police report, that is under section 241. In session trial, the word is used may convict. Here under section 241, the word is used shall, because of the punishment ratio. The punishment ratio is this ratio. If the accused person say that yes, I am convict, then instead of wasting the time, court may convict, I'm sorry, court shall convict the accused person on the acceptance of guilt. Whatever the punishment, that is depends upon the gravity of the offense. Of course, the court will take into consider whether it is the first offenses. If the accused person says, sir, under what circumstances I have committed offense, again section 225, 360 of the CRPC came into picture, provisions of the Prohibition of Offenders Act came into picture, and after considering all this aspect, court may convict the accused person. Please bear in the mind, if this conviction is there, there is no provisions of appeal. There is no provisions of appeal. The accused has no right to file an appeal against this particular person. That we will discuss while discussing the provisions of appeal. However, under section 240, when the court asks the accused person whether you plead guilty or not, if the accused person says no, he want to conduct the trial, then instead of section 241, directly matter go to the 242. That is called as evidence of prosecution. Please bear in the mind, as we are discussed under the session trial, there is no stage called as date for the prosecution evidence. Here, directly after rejection of plea of guilty, directly the prosecution witnesses came to examine by the court, subject to condition if the accused is not convicted under section 241. Now, what is this? The same procedure is applied. Section 137, 138 of the Evidence Act, the chief examination by the prosecution again the cross-examined by the defense lawyer. I hope you understand defense lawyer means the lawyer of the accused person. And in length, all the witnesses have been examined in order to show the contradiction. What is contradiction? If suppose the witness has deposed police officer something and he has deposed in the court different, the accused person can show the court, sir, see the contradiction. Say for instance, accused person say at 10 o'clock he saw he was witness there, where in court he says no, 4 o'clock. So these are the contradiction to show the veracity, the conduct of the witnesses. That is what the duty of the defense lawyer. And therefore, after examining this, that is the defense lawyer. Of course, there is no stage for the list of the prosecution witness, but it is the duty of the magistrate to supply the list of the witnesses in advance. Which witnesses are the witnesses, list of the witnesses which the prosecution is going to be examined. Once this list of the prosecution witnesses is there, then the public prosecutor here, I'm sorry, it's not a public, it is the assistant public prosecutor, because since we are in magistrate court, assistant public prosecutor will conduct the chief examination, defense lawyer will take the cross examination, and subject to the re-examination, that is if something adverse is there. Now this is the procedure we call as the gathering of the evidence. The prosecution will gather the evidence, and that too by the testing the veracity, the deposition of the witnesses. Now after once prosecution witnesses is examined, next stage came into picture directly, we call as defense evidence, because in all proceeding defense evidence is there. Here again, as we have discussed in session trial, it's a dual weapon. It's a dual weapon, and therefore, when you are on defense side, you should take utmost precaution while examining the defense witnesses. Unless you are confident that you have sufficient evidence, then and then only you can evidence that there is no mandatory. It is not mandatory to examine the defense evidence. Rather, the word is used may. It's choice of the defense. Nowhere under the Evidence Act, nor under the CRPC, it is mentioned that defense evidence has to be examined. Prosecution evidence has to be examined. Otherwise, if the prosecution failed to examine, that is called as failure of the prosecution machinery. That is the ground for the acquittal of accused. But non-examining of the defense witness is not the ground for the conviction. Please bear in the mind. Simply because accused has not stepped into witness box, or he has not examined any witness, this is the not the ground of the conviction of the accused person. It's a duty of the prosecution. It's a duty of the state machinery. It's a duty of the person who come before the court. Rather, remember the provision of burden of proof. He who came before the court, he who alleged, he has to prove. And what the accused person has to say? He has to just disprove the contents of the parties. That is the prosecution. You have to just show, see whatever his statement in the FIR and how he's contradict here. That is what the veracity contradiction you have to show in the to the court approve. And therefore, this even though this provision is there, but it has to be with the utmost care. Now, in this particular aspect, section 243, I'm talking about the defense of the accused. There is additional provisions is there which is not available in the session trial. Section 243 subclause 1 deals that under warrant trial and police report, accused person can submit his written version of the in writing to the court. Please bear in the mind, this is not written statement as under the CPC. This is not the answer. This is not the contrast. This is the story of the accused person. He may step into witness box and depose, and the prosecution will be cross-examined, or he may submit the written version under section 243. I'm sorry, 243 subclause 1, and after submission of written version, the prosecution will cross-examine this. But this written version is an admission of the accused person. It's one kind of, if something adverse is there, the prosecutor here, please bear in the mind that why I'm saying examination of defense witness is always dangerous. If in that written version you have submitted something adverse or which is going to adverse your position, then prosecution can use that particular statement against you, and therefore you have to take utmost care either when stepping in witness box or when you're submitting the written version. So after this, of course, there are so many things, there are so many judgments are there available, and after this procedure, once this procedure is over, then of course 313 statement is there, and after hearing the parties or the uh, defense witnesses directly under section 243 of the CRPC, then directly the next stage came into picture, we call as 248. There is no direct provision like under the session trial argument and all these things. Of course, argument is there, but there is no provision made. By criminal manual, it is provided after the defense witness, if it is at all they have examined the defense witness, the next stage is argument. Both the party will argue the matter, and under section 248, the court subclause 1, if the prosecution fail acquit, subclause 2, then court may convict, again subject to considering the provisions of section 225 and 360 of the CRPC, and depends upon the what we call the character of the accused person, the length, and talking length means the tenure of the punishment is will be fixed by the court, and matter will be comes to an end. That is under section 248. This is what you call the warrant trial on police report. So charge sheet, compliance, then the discharge, then the uh, plea of guilt, conviction of plea of guilt, prosecution witness, defense witness, acquittal, and conviction. These are the only 6 stages under this what do you call it warrant cases. Now come to the another aspect that is called as warrant trial otherwise than police. Section 244 to section 247. Now this is something very interesting which we are going to discuss. Why I'm saying something interesting? Refresh your memory and go back to the example which we have already discussed. That is, we call as the lady went to the police station, and after going to the police station, if the police officer, fortunately for her, registered the FIR, then warrant trial on police report. This aspect we have discussed. That is 238 to section 244, I'm sorry, 243 and the section 248. Now she went to the police station, police refused. She went to the lawyer, and her lawyer filed a private complaint by using the power under section 190, that is the cognizance by the magistrate. Now, in a complaint, see, I hope you understand at this juncture, complaint is always made to the magistrate, but unfortunately, as a practice, we are using the word complaint to the police station. No, complaint. If you go to the definition, complaint is always to the magistrate. It's a complaint made by the party to the court of law, because irrespective of the cognizable offence, the police has refused. Therefore, it's a complaint. Complaint to two authority, one to the police officer and second to the person who has committed the offence. Here, lawyer, instead of praying 156 investigation or inquiry, he simply say process may kindly be issued to the accused person. Then the provisions of section 244 to section 248 came into picture. That is the third aspect. See, the complaint is filed and he prayed to the court, so the process may kindly be issued against the accused person for the offence punishable under section 498A, section 323, 504, 506, read with section 34 of IPC, 34 because there are more than one accused, and court has order issuance of process. Now, at this juncture, you are aware, once there is an order of issuance process under section 204, the first section came into picture, that is section 61, summons. Court will issue the summons and party will appear. If the party appear, rest of the section from the chapter 3 will not came into picture. That is warrant, attachment, proclamation, all these things will appear, because everything is for the attendance of party. Now here, what is the procedure? When the issue process under section 204 is there, summons is served to the accused person, accused will appear to the court of law, and now this is the first time we are discussing, they may apply, they means their lawyer may apply to the court for bail. And now this bail, of course, we'll discuss while discussing the bail and bond. This bail is under section 437, that is to the magistrate. And magistrate will grant the bail. Now, sometimes magistrate will grant the police custody, also depends upon the gravity of the offence. But generally, you are aware, after the Arnesh Kumar judgments, especially under section 498, Supreme Court has given certain guidelines, including section 41A, non-twist has to be given. The gravity of offence is something reduced. That is different aspect. We'll discuss sometimes. But the police officer says, the court says, grant the bail. Bail is granted. Now this trial came into picture. What is this? Section 244 came into picture. What is this 240? When you enter into practice, this is even though it is not written anywhere in the CRPC, this is called as hearing before charge. There are two parts made by the manual, not by the CRPC. That is HBC and after HBC, hearing before charge and hearing after the charge. What is this hearing before the charge? Charge me, hearing before the charge. What is to be done? We will first discuss this, the so-called as the procedure which is developed by the lawyers and the judiciary, which is not in the books. Now, what is to be done? Since it is a private complaint, there is no need of compliance of section 207. Please bear in the mind, because there is no charge sheet. But along with the summons, if it is a private complaint, along with the summons, as we are discussing the CPC under order 8, along with the summons, it is a duty of the prosecution, that is the complainant lawyer, to attach the copy of the complaint to the summons, so that accused person should know what are the allegations against them. So This is indirect compliance of the similar compliance of section 207. So already they have complied. Copies has been served, all the copies. So there is no stage called as the compliance of section 207. Please bear in the mind, since this is not the state case means police has not taken cognizance. State case means in which the police has taken cognizance. Please bear in the mind, in a state case only, the government lawyer, that is called as prosecution, public prosecutor will be appointed. Here, it's a private lawyer of the complainant who will conduct the trial. Firstly, he will issue the copy of along with the summons. Then next stage he came into picture. That is called as hearing before the charge. What is that? He will examine the witnesses. If you remember, section 20201, all this has been deal with this. It is the initial duty of the complainant to examine himself and all the witnesses. Let us go through this example. That lady said, this must happen, and my husband used to beat me every day. She has to examine herself to prove the contents in the allegation. That is done. Then she has examined one of the witness who is staying next to her door. That witness appears and says, yes, hi, I used to hear some noise from their house, crying, shouting, etc., etc. This is giving the pendant to the deposition of the witness, that is the complainant. And since the allegation of the injury is there, she will produce the certificate from the hospital. And if the lawyer is available with the provision of the evidence, he will examine the doctor who has issued the certificate, because simply submit document is not important. You are aware the contents of document is to prove by the examination. All this aspect has been examined with the prosecution. Now I will take a pause. This is under section 244. We call it preliminary hearing in the prosecution case. This entire aspect in one aspect. Rather, in session trial we have discussed 4 stages, 4 sections for this. But under section 244, 4 stages are included under warrant trial, otherwise than the police. This is called as hearing before the charge. Everything is examined. Now you may put the question, sir, then what about the cross-examination of the all these witnesses? Here, it is a choice of the defense, which was not available to the earlier 2 trial. The defense lawyer may take the cross-examination of the witnesses at this level, or he simply say, I reserve my right to cross-examination after the framing of the that is called as the framing of the charge. He has a right. He may examine at the initial level, or he may subsequently examine. There is a choice. That is the choice. And this particular examination nothing to do with the court. After suppose after the chief examination, if the defense lawyer says no, I don't want, next stage came into picture. That is called as section 245, discharge. Second stage now. See, if after going through the complainant and all the witness, if the court come to the conclusion this is baseless case, no case is made out, court can directly discharge the accused person. See, here the accused person has neither cross-examined any witnesses, nor he has stepped into witness box. This is the initial discharge. However, if after examining the witness and complainant and the document produced before him, if the court come to the conclusion yes, something is there in the matter, then next stage came to picture, that is under section 246. We call as, that is framing. If the accused is not discharged, the next stage came into picture, that is called as the procedure when accused is not discharged. That is under section 246. If the accused is not discharged under section 244, then the magistrate will call the accused person. This is provided under one section itself, 245. He will call the prosecution, that is the accused person, and he will frame the charges against the accused. And the same procedure. He will read over, he will explain, and he will ask, are you plead guilty or not? And after this, if you plead guilty, then the Then the next procedure get. Then section 246 is there. If the accused is discharged, this is one of the history. I'm sorry, I forgot this. If accused is discharged under section 245, then there is additional procedure under section 246 with the accused person. That we'll discuss later on. However, if the accused is not discharged, 246 came into picture. Then again the court will call the prosecution to examine the witnesses. So this is the second time they have examined the prosecution witnesses. There is a choice with the prosecution. Why? Because earlier it is called as hearing before the charge. This is called as hearing after the charge. Here there is a choice with the prosecution. He may say under section 246, he may say, sir, I want to continue with my earlier witnesses, earlier deposition, and I don't again want to examine any new witness, or I don't want to again re-examine my earlier witness. I'm going with the same. Then after this, the court will call to the defense, that is accused lawyer, to examine this. Here, there is no choice with the accused. He has to examine, and refusal will acceptance. And therefore, after the framing of the charge, he has to examine. That is called as cross-examination. After cross-examination, that is the same procedure where the accused person has to done. He will examine the accused, all the witnesses. Again, he will show the court how the witnesses are deposing falsely, contradiction, variation, and the all these aspects he has to prove by putting the court by disproving the statement of the prosecution witnesses. And after over all these aspects, the prosecution will close the evidence. That is called as closure of evidence. And then section 247 came into picture. That is evidence of defense. Evidence of defense. So this again the word is used may. What is this? Here, all the provisions of section 243 will ipso facto applicable to section 246. This is simply what is that? The accused person will examine himself, or he may examine any other witnesses, and the prosecution, that is the complaint. Prosecution here means the private lawyer will cross-examine the defense witnesses. Same here. And after examination of the defense witnesses, then next stage came into picture again, section 248. Of course, argument is there. My dear friend, please bear in the mind, section 248 is common to both the trial. That is warrant trial on police report and warrant trial otherwise than the police report. So the provisions are applicable, section 248 applicable to all aspects. And accordingly, if the prosecution, that is the private complainant, prove the case, court will convict the accused under section 248 subclause 2, of course by taking the help of section 325 and 360 of the CRPC. If the prosecution fail, accused will acquit the accused person. This is all about the what do you call the warrant trial on police report or the police report, or otherwise than the police report. Now, after this, I am going to discuss one important aspect here. There is one provision made under the CRPC with reference to section 249. This is the section which has important, that is deal with the absence of complainant or effect of the absence of complainant. What will be happen if the complainant is absent when the matter is called for the hearing. Now, section 4, please bear in mind, section 249 came into picture only when there is a private complaint and matter is called for the evidence, that is the examination of witnesses. And after giving when the matter is in hearing and complainant is continuously absent from the court of law, he is avoiding the court of law, he is avoiding the dates of the court of law, then court may directly dismiss the complaint. And this is very interesting. If charges are not framed, then he will be discharged. And very interestingly, under section 249, if the matter is dismissed for non-appearance of the complaint, so when you are start the practice, don't do this. If you file a private complaint and your complaint is absent, and by using the power under section 249 it is dismissed by the court, then the accused person has a right to file a complaint for the compensation, for we call as malicious prosecution. If the complaint is dismissed under section 249, that is we call as want of prosecution. So you being a lawyer, you have to take utmost precautions of the private complaint. Lastly, lastly, under section 240, 250 of the CRPC, there is the effect mentioned. What is the consequences if the complaint is dead? I'm sorry, it is the compensation. As we had discussed, if there is a false case, the compensation is there. Either it is a defamation, libel, you all are aware. All the provisions are mentioned under section 250. That is for malicious prosecution. So with this, I hope you understand both the aspects. Please go through the writing portion, which I'm going to submit you on the your WhatsApp group. If you have any queries, any problem, please be free to let me know. Thank you.